Law of contract, voidable contract. A voidable contract occurs when one party would have agreed to the contract if they had known the true nature of the contract. With the presentation of new knowledge, the party above has the opportunity to reject the contract after the fact. This video will discuss reasons that can make a voidable contract. At the end of the lesson, learners should be able to achieve the following learning outcomes. We will begin with defining a voidable contract. Section 10 of the Contract Act 1950 stated, contracts, if they are made by free consent, party whose consent has been caused by all of the above can avoid the contract at his own option. A voidable contract is a formal agreement between two parties that may render it unenforceable for a number of legal reasons. Thus, the contract will remain valid until it is rescinded. The rescission must be timely, just, and fair. Clause I of Section 2 provides the definition of voidable contract as an agreement enforceable by law at the option of one party but not at the option of the other. From the definition, the word consent kept popping up. Section 13 of the Contract Act 1950 stated consent as where two or more persons are said to consent when they agree upon the same thing in the same sense. Hence, you can refer to consensus ad idem. Section 14 of the Contract Act 1950 stated the agreement is a contract voidable at the option of the party whose consent was caused by either coercion, undue influence, fraud, or misrepresentation. If the consent was not caused by any of the following, the agreement is valid. We will now look into the vitiating factors. Number 1. Coercion. Coercion is defined as the act of coercing, use of force or intimidation in order to obtain compliance. To invoke coercion, it has to be a clear utterance of the threat to commit act forbidden by the Penal Code, and it must be uttered with intention of causing the plaintiff to enter into an agreement. Section 15 of the Contract Act 1950 stated, coercion is the committing or threatening to commit any act forbidden by the Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. The said provision stated, coercion can be either in the form of a threat or an action. Coercion is confined to offences under the Penal Code. It is not extended to any tortious act or offences under the law. Example of offence under the Penal Code is public servant taking gratification other than legal remuneration, absconding to avoid service or summons, giving false evidence, harbouring an offender, counterfeiting a government stamp, criminal conspiracy, or providing devices to terrorist group, and many more. To learn more about this, please refer. In Barton v. Armstrong, defendant threatened to kill the plaintiff on multiple occasions and forcing him to buy the defendant's share. The agreement was said voidable as it was induced by coercion, as there is a clear utterance of a threat to kill, Killing is an offense under the Penal Code, and the threat was uttered to induce the plaintiff to enter into an agreement with the defendant. Coercion can also be in the form of unlawful detaining of property. An unlawful detaining of property to cause any person to enter into an agreement is considered a coercion. If the detention of property is not unlawful, there is no coercion. For example, suppose a mortgage refuses to convey the equity of redemption except on a specific term. In that case, it is not an unlawful detaining. In Chin Nambi Developments Sdn Bhd versus Tai Kim Chu and others, the plaintiff claimed additional payment from the defendants. The plaintiff threatened to cancel the defendant's booking as they refused to pay. The additional payment was under coercion of cancelling defendant's booking. Economic duress. Economic duress is also considered as a coercion. Economic duress is an unfair use of a dominant bargaining position. It occurs where a party to a contract threatens to cancel a contract unless the other party agrees in their demands. In Disney Builders versus Rees, the defendant, knowing the plaintiff is having financial trouble, took advantage of the situation and paid the plaintiff less than the amount that is supposed to pay. This is considered as an economic duress. Number 2, undue influence. The doctrine of undue influence is for granting transaction procured by exercise of insidious forms of influence, either spiritual or temporary. Undue influence is an equitable doctrine that involves one person taking advantage of a position of power over the other person. This inequity in power between the parties can vitiate one party's consent as they cannot freely exercise their independent will. Section 16, subsection 1 stated a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one party is in a position to dominate the will of the other, and that party uses that position in order to gain unfair advantage over the other. Undue influence can be satisfied if the relations between the parties to each other must be such in that one is in a position to dominate the will of the other. It must be proven that the other party was in a position to dominate the will. A plea cannot be raised by a third party. It can only be raised by the contracting party only. Section 16 of Contract Act 1950 stated there are 3 forms of domination of will. The first one is the real or apparent authority. Real authority means an actual authority. For example, police officers, judicial officers, or even the Prime Minister. Apparent authority indicates that the person is not holding any real authority, but shows the color of the authority of what it appears. Second is fiduciary relations. Fiduciary relations is where there is a presumption of undue influence, such as parents and child, solicitors and its client, or doctors and patients, or spiritual advisors over devotees. Next is entering into an agreement with someone who is weaker. Clause B of Section 16, subsection 2 provides a person deemed to be in a position to dominate the will of the others where he makes a contract with a person whose mental capacity is temporarily or permanently affected because of age, illness, or mental or bodily distress. Once it is clear that there is a domination of will, it must be proven that the party uses their power to gain unfair advantage for himself and cause injury to person. Section 16, subsection 3 stated the burden of proving the contract was not induced by undue influence actually lies upon the person in a position to dominate the will, and not the innocent party. Once it shows that a person was in a position to dominate the will of another, and the transaction appears to be unpassable, it raises presumption of undue influence. However, the person in dominating position has to prove that the other party consented freely. Undue influence can be seen in the case Olcart versus Skinner and Inchinora versus Sheikh Ali bin Omar. Number 3, fraud. Fraud means the using of false representation to obtain unjust advantage. The intention to deceive the other party is the essence of fraud. To commit fraud, a person asserts or misstates the fact that it should be acted upon. Fraud is proved when it's shown that a false representation has been made knowingly, without belief in its truth, and it was made recklessly. Section 17 of the Contract Act 1950 stated, fraud includes any of the following acts listed under Section 17. The act is committed by a party to a contract, connivance, or by his agent with intent to deceive and induce the other party to enter into an agreement. For example, A intending to deceive B falsely represent that 1,000 tons of sugar are produced annually in its factory. However, A is fully aware that his factory can only produce 600 tons of sugar annually. B thereby agrees to buy the factory. A has resorted to fraud to obtain the consent of B. Suggestion fallacy. The suggestion of a fact is true when it is not true, and the person making the suggestion does not believe it is to be true. Is considered fraud under Section 17, Clause A of the Contract Act. For example, a man over the age of 16 lies about his age in order to get an insurance policy. So this is an act of lying. Active concealment. Section 17, Clause B stated the active concealment of a fact by one having knowledge or belief amounts to fraud. It refers to the situation where a party conceals any information which they have to disclose. Active concealment results when the party takes positive or deliberate steps to prevent information from reaching the other party and which is treated as fraud. However, explanation under Section 17 states a mere silence as to the fact likely to affect the willingness of a person to enter into a contract is not fraud. Silence can amount to fraud only if a party is under duty to speak, and if he did not speak, it is constituted as fraud. For example, James wanted to sell his car. His son Bobby agreed to buy it at 10,000 ringgit. Here, the relations between James and Bobby would make it James' duty to tell Bobby the car's condition. Failure to do so, James committed fraud. Number 2, silence amounts to fraud if the silence itself is equivalent to speech. For example, Salman offered to sell his cat to Hamid. Hamid says to Salman, If you do not deny it, I shall assume the cat is healthy. If someone kept silent, his silence itself is equivalent to speech. Hence, it is considered as fraud. Section 17, Clause C of the Act stated, a promise made without intention of performing will amount to fraud. If a person entering into a contract has no intention to perform the promise, there is a fraud. For example, Sally promised to marry Johan. Later, he realized that Sally was already married and had made the promise without any intention to perform it. It was held that Johan can avoid the contract on the ground of fraud. Another example, a purchase of goods without intention of paying. The price is a fraud, and the contract can be avoided on this ground. Section 17D stated an act used to trick or cheat someone by unfair means. This category includes all tricks, dissembling, and other unfair ways used by cunning or clever people to cheat others. For example, Omar persuaded his illiterate grandmother to sign a document without telling her the document is actually to sell the house for a low price. Now, this is considered as an act done to deceive the grandmother. Hence, it is a fraud under Section 17, Clause D. Section 17E. It covers any act or omission as the law specifically declared to be fraud, will cause the contract to be voidable. This category includes the act or omission that the law specifically declared to be fraud. For example, the Insolvency Act and the Companies Act declare certain kinds of transfer to be fraudulent. For instance, under Act 1882, under Section 55, the seller of immovable property is bound to disclose any latent material defect in the property to the buyer. Not doing so will amount to fraud. In Lakshmi Aramugam versus Annamalai, the defendant has fraudulently represented to the plaintiff that the document she signed was for a loan she took and to free the land from a charge. However, the document is actually for the sale of land. Misrepresentation. In common law jurisdiction, a misrepresentation is an untrue or misleading statement made during negotiation by one party. The statement then induces the other party to enter into a contract. Section 18 of the Contract Act defines misrepresentation as an ambiguous false statement of fact, which induces the other to enter into an agreement. For an action to be successful, some criteria must be met to prove misrepresentation. This includes a false statement of fact, the statement was directed at the suing party, and the statement has acted to induce the suing party to enter into an agreement. In summary, a misrepresentation must include untruth statement, induce someone, and that person must suffer loss. Section 18, Clause A stated, innocent misrepresentation must be a positive assertion of a fact, and it must not be a mere opinion or hearsay. An assertion cannot be warranted for the purpose where it is based on mere hearsay. A person is committing any breach of duty obtaining advantage by misleading the other to his prejudice without any intention to deceive. The cases of concealment or suppression of fact also falls within Clause B of Section 18. Clause C of Section 18 stated, when a party innocently led the other to make a mistake is considered as a misrepresentation. In New Borneo Merchant versus Hajat bin Ibrahim, the statement of an assistant manager on the delivery time was an innocent misrepresentation. Now, what happens when an agreement is deemed voidable? We will refer to Section 19 and 20 of the Act. An agreement entered by coercion is voidable at the option of the innocent party. The innocent party may end the contract. For an agreement made by fraud or misrepresentation, the innocent party may either rescind or affirm and continue to be bound. If the party chooses to rescind, the contract will be deemed to have been valid up until the time it was voided. However, if the party had means of discovering the truth, the agreement is not voidable. A contract entered by undue influence can be set aside at the option of the aggrieved party, according to Section 20. Please refer to the case Wei Tah Construction and another versus Lau Woon Inc. to learn more on the exception of Section 19.